Court is calling 2021 CR 8476 State versus Beth Nicole Martinez. Can I have parties announced?
Ashley Jones for the state.
Robert Porter for Ms. Martinez.
Are you Ms. Martinez?
Yes, ma'am.
All right, did you review, and counsel, you have 10 days to prepare. Are you ready to proceed?
We are.
All right. And Ms. Martinez, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Beth Nicole Martinez who's placed on deferred adjudication in 2021 CR 8476 for the offense of aggravated assault with a deadly weapon on October 12, 2021 for a period of 4 years? Is that you?
Yes.
All right, state.
Yes. State's going to proceed on violation of condition number 2 on or about the 7th day of October 2024 in Bexar County, Texas. The defendant, Beth Nicole Martinez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
State.
The state will waive the remaining violations.
No objection.
All right, did you understand by pleading true to violation condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, will you still wish to prove true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there proposed agreement?
Partially, Your Honor, the agreement was for her to plead true to violation of condition number 2. I do believe defense and I both have different recommendations. The state's recommendation is that she receive some sort of inpatient treatment given the positive UA and the failures to submit, but I do not see any evidence of mental health directives. I mean, the only thing we have is going back as far as 2021. I don't have any current on that to show that there's DPRF.
It's my understanding, Judge, and I think the state checked into this also. Felony drug court, she was in phase 5. They checked into that. What that is, that's the aftercare program. If the court takes notice, the last drug test was back, I want to say 30 years, it was either September or October, the October one. We don't know if she's pregnant or not. She may have miscarried. They will find out this week. Having said that, Judge, we would like some form of outpatient treatment, maybe weekly UAs. It's like like I told the state, you're running the 440-yard dash, you make it to 435 yards, and then we don't quite complete it up. Now we're going to have to start another 9-month program. At the time this happened, her father had just passed away from cancer. She was trying to take care of the estate and stay in his house. It became overwhelming for her at that point in time. I think that's where she got off track.
I actually did ask them for help. I asked them if I could ask alumni for help with my father's funeral. I even asked if I could put his fundraiser out there. And the case manager at the time, CJ, denied it. She didn't even let me bring it up to alumni.
But now here's the thing. It's not about whether or not you can do a fundraiser. It's about I'm struggling because I have all of this hitting me at once. I'm struggling in the sense that I may not do my UAs. I may fall out of this program. That's what it's about. It's not, I'm struggling. I've asked you for A, B, and C, and your answer is no, I'm not doing A, B, and C. So therefore, I'm just going to stop submitting you to drug testing. I'm not going to do any of this.
I actually even did ask my judge if he can move me case managers because we weren't seeing eye to eye. I didn't get that, and I tried to work with my case manager. I did good the whole time I was on it.
So let me ask you this. Here's the question. You asked for your case manager. You tried to work with your case manager, and it wasn't working. So your response to that was to do what with your probation?
I was with someone. I had too much stuff going on. I was losing my
so
house.
Your decision with probation was what? With felony drug court. See, I'm trying to get you to point because
well, I know where I messed up. I'm not saying I didn't.
Yeah, but so that's the thing. You didn't learn anything from felony drug court because let me just explain something to you. Everybody in this court has a bad day. Now, some may have a bad day that is not as bad as others. Let me just tell you what happened to me. I had a client who was on parole. I had a parole hearing scheduled for them. You can unfold your arms. I had a parole hearing scheduled for them. I knew that they had mental health issues, and I knew that they were depending on me to be there for their parole hearing. All right, so I'm sleeping, everything's going well. I get a call at 3 a.m. It's a Monday, I get a call at 3 a.m. And you know what that call is? It's from my younger brother, and guess what he tells me? Grandmother died. Now, what do I do in that situation? I know I got a client who's expecting me, who has mental health issues, who maybe won't understand. I know I'm an attorney for children on CPS cases who are not going to understand. So do I just throw my hands up and say, you know what? This is what's going on in my life. I'm not calling anybody. I'm not doing anything. You all handle it. See you later. It's called adulting and growing up. So what did I do? My mom, of course, was upset. She's like telling my brother, why don't you call her? You know, it's late. She's far away. She's all the way in another state. But I went and I did the parole hearing because that person was depending on me. I went and visited children because they were depending on me. And then I got a flight and left for home. And I left messages to everybody. Hey, my grandmother just died. I'm going to have to go home. So I tell you that to say everybody has problems in this world. But your problems in this world, you're supposed to be able to deal with that. And dealing with that when you're looking at 20 years in prison is to, when somebody says, no, we're not going to do that, then you got to accept that. You're on paper. That's what we called it when I was a defense attorney. You're on paper, you're looking at 20 years. So here's my question. Is the TAP evaluation updated or no?
Your Honor, the TAP evaluation I have from probation is from 2021. I do not see, I don't have any information.
All right, so we need an updated TAP evaluation. So I'll find number 2 true. I'm going to give you a choice. I can deny the motion. You're not getting out of jail today. You're going to do the TAP evaluation in custody. If the TAP evaluation says you're going to inpatient, you're going to inpatient. Or what I can do is I can revoke you and I'll give you 3 years. Those are your choices.
And how long does the TAP evaluation take?
It won't be long. I think that's the right choice.
Will I get my back time if I sign up?
Sure. All right. We're back on the record. Yes. So what do you want to do?
Do the TAP evaluation.
All right. So the court will deny the motion, alternate amend conditions to include in custody. There's to be a TAP evaluation, follow all recommendations, and there's also to be an updated MIC evaluation in custody. And is there anything else that's being requested?
Right away notice what's happening here. The defendant openly admits she stopped complying with drug testing in probation world. That's not a small slip up. That's basically telling the court, I'm done playing by the rules, and judges do not take that lightly.
State.
No, Your Honor.
And is there anything else you need from the court, Miss? Is there anything else you need from the court?
Amen.
All right. And there's to be no residence with minors. All right. Thank you.
Thank you, Judge.
You're welcome.
Nathan Valley, be excused.
Yes. Court is calling 2024 CR 011095 State versus Luis Okura. Can I have parties announced for the record?
Andrew Harris, Edelman.
Hector Gar Jr. for the defense.
And are you Mr. Okura?
Yes, Your Honor.
Just 1 second. Counsel, have you received all discovery and did you review it with your client?
We have.
Court will find that the state is in compliance with discovery. Is there an application in this case?
There is.
Did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do wait.
Are you proceeding on the indictment as presented?
No, Your Honor.
Any objection?
No objection from the defense.
Mr. Okura, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in count 1, you're charged with the offense of aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you're giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I feel that he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I feel that he is and was.
Mr. Okoro, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count one. They're asking that your punishment be assessed at a cap of 6 years in the prison. There's a $2,000 fine. State is silent on your application. They're taking consideration night mag number 760070. There's to be restitution and no contact to the complainants. Did you understand that to be the plea?
Yes, Your Honor.
And did you understand if the court were to determine that there is a weapon used, the court would make an affirmative finding of a deadly weapon? All right, defense, is that the plea?
It is.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there many such motions?
There has not.
Then to count one, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
No objections from the defense.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, if you want to set this for a PSI, it'll be 8 weeks. But if you would like, what we can do is I can reset it for a sentencing and you can bring in whatever witnesses you would like to bring in. And I'll ask the state for his criminal history. So which would you prefer?
We're going to bring in several witnesses, Judge.
All right. So are you waiving the PSI then?
Sure.
This is one of the most important warnings in the entire hearing when the judge says up to 20 years. That's not courtroom drama. That's the actual statutory maximum. Pleading true means the court now has full power to send her to prison.
Right. So what date would be good for you, counsel?
I would like to look towards April, Judge, just to make sure that we can coordinate with the individuals. At this point, I have the 22nd or the 23rd available.
I can do it the first week in April.
I am in Del Rio and then Eagle Pass 3 days of the week, so I'll be out from Monday through Thursday.
Mhm.
The following week, the earliest I would be able to do is the 10th.
All right. Ms. Ferguson, if you'll put this for April 10th for sentencing and the PSI is waived, and we can go off the record, what ended up happening, the state is silent on your application. The only thing I'm going to need from them is your criminal history, if you have any.
There is
And then I will hear whatever witnesses or evidence your attorney wants to present to the court. And then I'll make my decision on your application based upon any evidence that I hear or receive. Okay. Do you have any questions about anything? All right. Once you sign the reset form, you'll be excused. Just have a seat and your attorney will bring it to you.
Your Honor.
You're welcome.
Thank you, Judge.
You're welcome.
Yes, we do.
Hello, Ms. Martinez. All right. So what is the update on the evaluation?
2 weeks ago, she was found incompetent. We should be going back again to that court. She wanted to order some other testing because it was believed, and after she's done with her treatment, that she will become competent. That will take a while. So that's where we're at right now. And I think we got another hearing this week to discuss the other testing that the state was smart to give her, some more some more evaluations to try to help her understand her problems better, as well as the people that are treating her.
All right, Norma, set this for the fourth week in May, please. Isn't that a holiday?
Fine.
All right, May 27th.
Oh, excuse me.
All right, we're going to bring you back to this court on May 27th. We can't go forward on anything until a doctor states that you are currently competent, okay? Do you have any questions?
For Cordova,
I'm sorry, you have what?
for Cordova, because something that I was trespassing and that I had spit on his mouth, which is I didn't. I had a.
All right, so
wash
let
my
me
mouth. It's
explain.
already 3 times a year.
So it's probably best for you not to speak about your case. All right, so, and I just say that for your protection, because your attorney may have different defenses that he wants to put forth in the court. But what I can tell you is, until I get something from the magistrate's court saying that you're competent, I can't move forward or do anything with this case. You understand?
Okay.
All right. All right, thank you so much.
Thank you, Your Honor.
You're welcome.
And I'd be excused.
Yes, you may be excused.
Thank you, Your Honor.
Mr. Sullivan, you still have another client.
Oh, I do?
Yes, he's gonna go and get him.
Melissa Johnson.
go get him.
So you can put her up.
Okay.
Thank you.
Get it off.
Oh.
Yes, he can. Now, can you go to the second one?
All right, this is contested, correct?
We're gonna put you to the number 5, Judge, the felony report.
Right. Court is calling 2020 CR 11653, State of Texas versus Corlissa Donora Johnson. Could I have parties announced for the record for the state
Ashley Jones for the state.
defense?
Jim Wheat.
And are you Miss Johnson?
Yes, ma'am.
Your Honor, I'm sorry. I don't know.
Sure. If y'all want to step back and confer, you can.
Please, Judge.
All right, just have a seat and I'll call you up when they're ready. Who are the attorneys on Matthew Salazar?
All right, guys. Ready?
State, are you ready?
Yes, Your Honor.
Okay.
Here's the emotional pivot point the defense is arguing: mitigation, grief, loss, pressure, and burnout. This is where courts have to decide, is this someone spiraling or someone making excuses? That distinction can change everything.
I do.
I'll give it.
My notes are on that. Okay,
If you want to give him that back, I can give you mine.
that's fine. She can.
All right. All right. Court is calling 2022 CR 3264, State versus Matthew Salazar. Excuse me, guys, we're on the record. You need to ask the deputy to move you down there. State versus Matthew Salazar. Can I have parties announced for the record for the state?
Ashley Jones for the state.
Robert Porter for Mr. Salazar.
And are you Mr. Salazar? Are you the same Matthew Salazar who was placed on community supervision in 2022 CR 3264 for the offense of assault of a pregnant person on December 8, 2022 for a term of 10 years? Is that you?
Yes, ma'am.
All right. State?
State is moving forward on violation of condition Salazar. That then and there fail to apply for, provide documentation of attendance, and comply with all rules, regulations, instructions, and financial agreements as directed by the court and/or supervision officer and/or the head of or authorized personnel of the following program: battering, intervention, and prevention program, in violation of condition number 14.
How do you plead to that? True or not true?
True, yes, ma'am.
All right. State?
Violation of condition number 39, on or about the 19th day of April 2024 in Bear County, Texas, the defendant Matthew Salazar did then and there fail to submit to an evaluation for placement into the drug court in violation of condition number 39.
How do you plead to that? True or not true?
True, yes, ma'am.
Violation of condition number 42, on or about the 7th day of August, 2024 in Bexar County, Texas. The defendant, Matthew Salazar, did then and there fail to submit to a substance abuse evaluation with the Bexar County CSCD's treatment alternative to incarceration.
How do you plead to that? True or not true?
True.
The state will waive all
No.
violations.
No objections.
Did you understand by pleading true to violation of conditions 14G, 39, and 42, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to 14G, 39, and 42? Court will find 14G, 39, and 42 true. Oh, did you all fill out an application, a trial court certification?
Well, he's on probation, so there should have been one already filled out.
That's okay.
Apologies, Jeff.
Yeah. Well, you know what?
Nice is
They
that?
ran out of paper,
Hmm.
you know, the regular one. So this is what they've given us. All right. Is there a proposed agreement?
There is not, Your Honor. We had a partial agreement to plead true to those conditions, so they are not contested, and to waive the other violations. And then I believe we're going to open to the court with the recommendation of the state and the defense's argument for their position.
All right. So are there any witnesses?
No, you don't.
All right. State, what are you requesting?
Your Honor, just given the seriousness of the offense for which the defendant was placed on probation for, he did receive 10 years, probated for 10 years, so he is subject to the underlying sentence for 10 years. For, I do believe he's been on probation since 2022 and he has not done the Veterans Intervention and Prevention Program. He did have substance abuse problems, and clients that address those problems have been thwarted by the defense. And so for those reasons, Your Honor, state's position is that he's shown that he doesn't want to be on probation, and the court should sentence him to corrections for a period of no less than 5 years.
All right. And defense, what are you requesting?
Two things, Judge, if I may address a couple of things. We're going to respectfully request that you continue him. A couple of things about the Battery Intervention Program. And he actually was signed up for that back in April. Went to a couple of classes. He was having trouble communicating with his probation department. I showed emails to the state of Texas about.
This is a classic judicial reality check. The judge isn't minimizing her pain. She's reframing responsibility. Courts care less about why life got hard and more about how you responded when the consequences were already spelled out.
That we weren't, I wasn't lying about just probation department just stopped communicating with him after a certain date. So he freaked out and said, I'm not going to do it. He was arrested, and before this court, I was appointed 2 weeks ago. He made bond. Since then, he got out. He has signed up for the Battery Intervention Program, and he's set for his first class on Thursday.
So why hasn't he followed the court's instruction with regards to felony drug court?
Well, I'm going to get to that. I'll go one at a time.
All right. I like the one at a time.
He did speak to the probation officer, and she did say that she would make attempts to. That's right.
The drug court. The drug court also, Judge, he was notified, and this is through a series of emails from the state of Texas, that we've shared all this stuff together already. And so we're trying to give it in a nutshell. On 4/22/24, he did not qualify for drug court. Now, since that time, they still asked him to come to the court, I guess, to tell him you don't qualify, what have you. On 4/25, he had called up his probation officer and told them, listen, I've been in the hospital. And they said, well, unless you show us some kind of proof that you're in the hospital, we don't care. As of today, I don't have it printed out, but I did see it, Judge, and there's an office court on the town. He was in Methodist Hospital from 4/27 to 4/29, which lacks the it was the 25th is the day we're talking about, so that's 2 days. However, I'm speaking with him and his wife. He was sick on the 25th. They had gone to Mission Trails first, which is the
All right, so
hospital
let's-
transfer. So anyway, so the drug court, he
What
didn't
about the
qualify.
19th, April 19th? Because on April 19th, it says that he failed to submit for an evaluation for placement in drug court.
From my understanding, but that was, it even goes back further than that, Judge. I think that the train of emails go back further than that, about the dates of what was happening and dates being moved.
All right, I need to
So-
see that, because otherwise I'm thinking he would need to go to prison, but I want to see the email in regards to April 19th.
Well, there's going to be a trail of emails,
Yes.
because they start like all the way back in April.
It's the case codes for the drug court supervision officer.
All right, so if I could see those.
And then the TAP judge, other than the TAP, again, we're taking full responsibility to TAP because we don't want to do that. But at the end of the day, when it came to the TAP and talking to the probation officer, he was told that they were really backed up and he'd be notified later on, and he was never notified.
Let me ask you this, and if your client is drug tested today, is he still going to be positive for marijuana?
He should be clean, Judge, and that was going to be my second option, Judge. I know there's been a history of the marijuana. We go back and look at it too, and in fact, when he was back in front of this court, he had just got in or just got out of jail, so he had this, but he's been clean for a month, and that reminds me of something else. He's been going to AA meetings since April of 2024, and I did get a letter from his AA sponsor who says he does AA every Friday. He's been doing it every Friday for the past since April of 2024. In the alternative, I know the probation had asked for, and we are in agreement, should the court decide not to continue him out on the street, probation is asking for Saturday.
He's saying it's safety.
Oh, I'm sorry, safety. Yeah.
All right, here's my question. Has he done a TAP evaluation? Because in the motion to revoke, it says no TAP done.
I don't think a TAP has ever been done.
And does anybody have the court summary?
I have one.
Any objections to the court reviewing?
Not for the facts.
Now we hit the fork in the road. The judge offers two stark options: treatment evaluation or prison time. This isn't a negotiation, it's a pressure test. Judges do this to see who's actually willing to do the work versus who just wants out.
All right, so this is one of my questions from reviewing the court summary. So it says that he claimed that he was already enrolled in BIP with CPS. So I'm assuming that's not true.
Judge, you'll have to, I don't know that answer.
All right, Jenna, raise your right hand. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record.
Happy Salsa?
All right, so in the court summary, it states that you told them that you had enrolled in BIP with CPS. So is that true or no?
Yes, ma'am. I already did I was enrolled with the BIP, but I got incarcerated for CPS, but I finished my parenting classes and all that for them.
No, BIP is something completely different from
Battery
parenting.
intervention.
Yeah, it says on February 6, 2023, the probationer reports he enrolled in BIP with CPS. On March 10th, 2023, officer inquired about BIP and he started crying, states they are giving him the runaround. On April 12th, 2024, officer inquired about BIP and he stated he sent the packet and has not heard anything. On May 14th, 2024, the probationer called and states he called about the BIP and they told him the price. Officer informed him to register ASAP and he states he will try and get the money soon. Officer received a call on June 11th, 2024 from probation stating if his appointment to report should be rescheduled due to his daughter award ceremony. So the question becomes, did you enroll in BIP through CPS or no?
Yes, ma'am. I did, and then I was enrolled. I enrolled in it.
I don't know about the CPS. I know he had enrolled in this, which is
Any objection to me? Does anyone want a search warrant for the cell phone?
We're not gonna do that. We're not gonna do that. That may be, there's a couple of the things on there, Judge, that I need to,
All right.
if that's not.
I won't swipe right.
No, that's.
Is this an Android or is this?
It's an Android.
All right. So I know how to use it to.
There's actually two different phone numbers that a lot of this paperwork was texted to me on, Judge, and I'll be happy to kind of flip back and forth.
Okay. All right. Is there anything else?
Not from the state.
Just again, just a couple of last things that goes to the allegations, Judge. He does work full time. He works for Lone Star Mobile Home Installers. He transports mobile homes. He's a father of two, actually a father of three, but he takes care of two full time. And so we're respectfully requesting either to continue and let him work these issues, and if he can't do that, then probation's recommendation.
All right. So here's the thing. You're getting drug tested today. What are the results going to be? And now's the time to tell me. If it's going to be positive, now's the time to tell me.
I was in jail for the last about a month, and I've been out clean. I didn't mess with anything when I got out of jail, man. I didn't do anything except smoke cigarettes. And last night I took NyQuil. That's about it because I've been feeling sick.
See, so here's the thing. We're doing NyQuil, and the last time there was an issue with alcohol.
But I explained to him I'm sick. I did take it because I was sick last night.
Well, here's the thing. You're not supposed to be taking alcohol at all. Those are not my rules. That's the legislature's rules.
Oh, I didn't realize.
You can't drink alcohol at the house when you're on probation. Can't do marijuana in your house. Just not allowed.
With Dayquil and NyQuil, like for cough and congestion.
No, see, you're not hearing me.
It's not.
Let me ask you this. Do you read the label on that? Is there alcohol in that? Yes, there is. Dayquil, is there alcohol? Yes, there is. NyQuil, is there alcohol? Yes, there is. You're not allowed to take anything with alcohol in it.
Sorry, I was not aware of that. I'm sorry. I was just sick.
You should have been aware because you tested positive for alcohol before.
I thought I had COVID. It didn't feel good at all.
Well, NyQuil is not going to help you with your COVID. I mean, I'm not a medical doctor.
Yes, ma'am.
I play one on TV, but.
Yes, ma'am, but I have not changed any drugs or anything.
Okay. All right. Anything else from either side?
Not from the state.
Approve that.
Probation. So you all don't have a TAP evaluation on him. Am I correct in saying that?
Yes, ma'am, that's correct.
All right. Can we get an expedited TAP on him?
Let me send a check out to you.
Thank you, State. You may be excused. All right, let's do this. Just have a seat in the box. They're gonna tell me about this expedited test.
Thank you, Judge.
This moment matters more than people realize. NyQuil sounds harmless, but probation conditions are strict. Alcohol is alcohol, even in cold medicine. This is how small choices quietly snowball into major violations.